No, you gotta, they're not here yet.
I'm sorry, I'm really only allowed to hear on the voice.
It's the first day.
Senator Atlas is gonna lead us in the pledge. Is that right? Pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Senator Carson is going to start us off with SB 26. Welcome, Senator Carson.
Thank you very much, Mr. Chair. For the record, this is Senate Bill 29.
Yeah, I saw that. Thank you.
An act relative to repealing statute relating to police make. For the record, my name is Sharon Carson. I have the pleasure of representing District 14, comprising the towns of Londonderry, Hudson, and Palmer. Mr. Chairman, this bill, quite frankly, is very simple. It really brings, it's asking us to strike what is an antiquated and quite honestly offensive term in our statute that refers to female police officers as police matrons. These are police officers. I want to make that very, very clear. And we have a number of women in blue that represent our communities across the state, and they should be treated with respect. And that is the purpose of this bill. The New Hampshire Association of Chiefs has asked me to bring this bill forward. This statute has been in effect since 1915, and it is time it goes. So, Chief Emily Cobb from the New London Police Department is here to testify and can answer any questions that you have. So, thank you very much for your consideration. And if you have any questions for me, I'll try to.
Thank you, Senator Carson. Seeing none, thank you.
Thank you.
Chief Cobb, how you doing today? Nice to meet you. Just watch out for our wires. We were running them over this morning in Commerce.
Good afternoon, Chief.
You know, you can do something about that. So he was right. I soon reached out to Beth Sargent and kind of got the ball rolling from there. And I'm honored to be here before you today, testifying on behalf of myself and the New Hampshire Association of Chiefs of Police. Madam Chair and members of the committee, this RSA was enacted over 100 years ago in 1915. A lot has happened since then. Over those 100 plus years, many, many women have proudly taken the oath, honorably worn the badge, and bravely protected the people of our great state. In recognition of all the women who came before me and my fellow female law enforcement colleagues of today, I offer my gratitude to them, their families, and their sacrifices. As female law enforcement professionals, we bear many titles in addition to that which is inscribed on our badge: wife, mother, daughter, sister, friend, and more. But one title we should not continue to permit in the codified laws of the state of New Hampshire, however, is matron. The Merriam-Webster definition of matron as it pertains to a police station is a woman who supervises women or children. That was indeed the role of women in New Hampshire law enforcement in our history, a role in which they fulfilled a valuable and critical need in the protection of people in our society, a role that they should be applauded for. However, times have changed and New Hampshire law enforcement has evolved. I offer to you, Madam Chair, and members of the committee, that the women in New Hampshire law enforcement today are certainly more than what this outdated statute provides for. On behalf of myself, my fellow female law enforcement colleagues, and the New Hampshire Association of Chiefs of Police, we are asking that you repeal RSA 1055 as it is an antiquated statute that can be removed from New Hampshire law. We ask that you vote ought to pass on Senate Bill 29. I remain grateful for your consideration and appreciative of your time today. Thank you. And I'm happy to answer any questions that you may have.
Thank you for your testimony this afternoon. Are there any questions from the committee?
Thank you, Madam Chair, and thank you for raising this issue with us. I think it's something that certainly needs to be addressed. I'm wondering if you can share with the committee how many police chiefs that are women in New Hampshire.
I believe there are 7 or 8. It's not a very large number, but there's certainly a handful of us, some of whom are represented here today.
Thank you.
Thank you very much.
Thank you, ma'am.
Thank you, Madam Chairman. For the record, my name is James Demers, and I'm here today on behalf of the New Hampshire Police Association. First, I want to say that it is an honor to speak and support this bill and stand with this outstanding group of women who are a key part of law enforcement in our state. In addition to having chiefs, we have dozens of women who serve as law enforcement officers, state troopers, and this is one of those bills that is 108 years late in being repealed. So I am honored to speak and make everyone aware that men stand behind this bill as well as women in law enforcement to update our law and give the equal treatment that women deserve who protect us every single day.
Thank you very much for your testimony.
Thank you.
Seeing none, thank you very much. Are there any other members of the public who would like to come forward to testify on Senate Bill 29? Seeing none. Here is your motion to go to executive session. Senator, seconded by Senator Tim. Okay, so we have in front of us Senate Bill 29. Is there a motion on Senate Bill 29?
I move OTP.
Okay, Senator Leslie moves ought to pass. Is there a second?
Second.
Seconded by Senator Chandler. Okay, is there any discussion on the bill? I think it's pretty self-explanatory. It's time to update the statute and get rid of this offensive term. So, all in favor say aye.
Aye.
Any opposed? Okay, can I get a motion for the consent calendar?
So moved.
Moved by Senator Whitley, seconded by Senator Chandler. Okay, is there any discussion on the consent calendar motion? Seeing, oh, it is on.
No.
Oh. Okay, usually red means stop. So I'm looking at this, it's like red, it's not on, so. Okay, so we have a consent calendar motion that's been moved and seconded. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye, any opposed? Okay, so it'll be on consent, and Matthew, I will be responsible for the work. Okay, it's a good way to start the day. Thank you very much for being here. This is gonna go. So, thank you. Okay, let's see, 27, when is that supposed to be here? At 1:10,
Thank you.
and I have 1:11, so we're good. Okay, okay, she's bringing up the We kind of move fast, Senator Abbas.
See, I think you should be over there next to Rick so we can see you. But I guess, I know she wants you there, so she's the boss. We're fine. I used to get to look at Harold. He'd call in the place.
I'm going to open the public hearing on Senate Bill 27 and recognize the prime sponsor, Senator Gannon.
Thank you, Senator Carson. I am Senator Bill Gannon from the center of the Wine District in Sandown, New Hampshire. SB 27, this bill amends RSA 15A3, persons required to file statements of financial interests. This bill would allow a judge's financial disclosure filed under the Code of Judicial Conduct to satisfy the filing requirements under RSA 15A. The amendment tracks the language that allows legislative disclosure form filed by legislators under RSA 14B8 to satisfy the requirements of RSA 15A. The change will eliminate some existing confusion as to whether and when judges are required to file statements of financial interest and what forms get filed. The Judiciary asked me to file this bill, and I think it's pretty straightforward. And they're behind us if you had any questions.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Seeing none?
Thank you,
very
Madam Chair.
much. The chair will call Richard Head.
Morning, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. And thank you, Senator Gannon, for introducing the bill. This is a bill that we did request be brought forward. And as Senator Gannon said, it's simply to avoid some confusion that exists. 15A has very limited circumstances in which judges under that statute are required to file financial disclosures. They all file, when they're appointed, and annually a financial disclosure form through the Judicial Branch rules. And we're simply asking that financial disclosure be allowed if under those rare circumstances where a judge be filing under 15A, that the judicial disclosure satisfy the requirement. It tracks the language that's currently in the statute for legislative financial disclosures, where the legislative financial disclosure form also satisfies 15A. What we find is some confusion when judges are appointed. The executive council will send them a 15A form. Some of them fill them out, some of them don't. We get a lot of questions simply as to who has to file what when. So this simply would clarify that the judges only need to file the judicial disclosure form, and that would satisfy both statutes. I'd be happy to take any questions.
Thank you very much for your testimony, Mr. Head. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Are there any other members of the public that would like to speak to Senate Bill 27? Okay, seeing none, I'm going to close the public hearing. Okay, is there a motion to go into executive session? Moved by Senator Whitley, seconded by Senator Chandley. Is there any discussion? Okay. Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion on Senate Bill 27?
I will vote TP.
Okay, Senator Whitley moves on to pass. Is there a second? Senator Gannon seconds. Okay, is there any discussion on the ought to pass motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion for the consent calendar? Moved by Senator Whitley, seconded by Senator Chandley. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, Senator Gannon? Sure. This is your bill. Okay, can I get a motion to come out of executive session?
So moved.
Okay, moved by Senator Whitley, seconded by Senator Chandley. Okay.
She's got.
Okay, so moved by,
Harold used to do.
moved by Senator Chandley, seconded by Senator Whitley. All in favor say aye.
Aye.
Any opposed? Okay, the committee will be in recess till 1:30. Which is when the next bill is scheduled. So we got 15 minutes. So if this is Matthew's gonna give some time to get caught up. Because we kind of moved like that.
Starting off with a bang.
Yeah, well, we gotta move through.
Good.
I'm trying to get it into a favor. Gabrielle, if you'd like to take this for. We have to see if we want.
How we go for the smoke.
That's
Right,
that it is 1:30, recess, and then hold the public hearing on 38, and recognize the sponsors and our hearing.
Thank you, Madam Chair, again. I'm going to introduce SB 38, and it amends RSA 594-14, summons instead of arrest. I thought it was straightforward. It was a request to the judiciary, but others in the room may tell me why I was in error. But we'll tell you what it was about. It would authorize law enforcement to issue a summons in lieu of an arrest if the officer has probable cause to believe a person has committed a misdemeanor or violation. So the way I understood it, Senator Carson, would be, let's say you failed to renew your dog license. That would be a violation. Even though it is only a violation under RSA 594-14 in its current form, arrest is the only option for law enforcement. This bill gives law enforcement the ability to issue a summons when arrest is not appropriate or necessary. While current law allows a judge to convert an arrest warrant to a summons, it unnecessarily requires law enforcement to file with the court, resulting in an unnecessary use of law enforcement and judicial resources. The Judiciary branch has asked me to bring forward this bill with both the chiefs of police and the ACLU, and they both indicated that they support the bill. Thank you, Madam Chair.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Seeing none.
Thank you, Madam
Thank you very
Chair.
much. The chair will call Richard Head. Good afternoon, Mr. Head.
Good afternoon. Thank you, Madam Chair. Thank you, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. As Senator Gannon said, this was a bill that we had requested basically in terms of just the administration of paperwork and time where it may not be necessary. Current law provides very limited opportunities where law enforcement is able to issue a summons if the offense was committed in their presence, certain domestic violence or protection order violations, and if there's an issue relative to willful concealment of evidence that may occur if the time was spent to get an arrest warrant. This bill essentially would give the authority, but would not mandate that law enforcement be able to issue a summons in lieu of arrest. In those circumstances, where we see it, as Senator Gannon said, these only address misdemeanors and violations. So if somebody has an unpaid dog license, that's a violation. Technically, right now, an arrest warrant would have to be issued in order for that to be enforced. If after notice from the town and et cetera, ultimately, if the town were to proceed with bringing it forward as a violation, an arrest warrant is the mechanism. There are some clunky ways of avoiding that. So as Senator Gannon said, a judge is able to convert an arrest warrant into a summons. Sometimes what will happen is that the arrest warrant is issued, and then law enforcement will contact the individual, have them come to the police station, and a summons will be issued at that point. But we're consuming a lot of resources essentially to do an end run around something that can exist if the statute is amended. And that's what brought forward our request for this amendment, simply to make it somewhat more streamlined where circumstances are appropriate for the issuance of a summons in lieu of an arrest warrant. With that, I'd be happy to take any questions. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Mr. Head, was this filed in the House last term?
Certainly not by us. I don't believe so, but not my memory is no. There was one that dealt with hospitals and summonses or the authority of police to arrest in a hospital where they didn't observe something, but a different type of bill. In ACLU, and I talked about that with ACLU, and they admitted it was a different bill. So I don't think so, is the short answer.
Okay, thank you. Are there any further questions? Okay. Seeing none, thank you very much.
Thank you.
The chair will call Trixie Lefebvre.
Good afternoon, everybody. Thank you, Madam Chairman, for allowing me to give this testimony. My name is Trixie Lefebvre. I live in Londonderry. Senate Bill 38, criminal trespass, simple assault. indecent exposure, criminal mischief, criminal threatening, theft by unauthorized taking. What do all these crimes have in common? They have a victim attached to it, and each of them is a misdemeanor. Victims are entitled to protection from their perpetrator. Bail conditions set at the time of the arrest are a tool in place for such protection. In this present legislation, it would appear that no such tier of protection would be considered for the victim. This legislation will establish policy which is not in the best interest of protecting the citizens of New Hampshire or its visitors. Placing conditions on a defendant while they are engaged with the court is a safety measure that should not be underestimated. These conditions can only be stated in a bail order issued by a judge or a bail commissioner. I speak from my experience as a bail commissioner, just so the whole panel knows. This Senate issued a statement just days ago promising to focus on keeping our communities safe. It then introduced this bill on Friday, January 6th, and rushes it to a committee hearing today. Clearly, by the notes attached at the bottom of this bill, no agency other than Judicial who requested it has had an opportunity to read it, digest it, or take a position. Senate Bill 38 does not protect victims, nor does it protect our communities, and it is entirely contrary to the Senate statement of January 4th. I urge members of this committee to oppose Senate Bill 38.
Okay. Thank you very much for your testimony. Are there any questions from the committee? Okay. Seeing none, thank you very much.
Thank you.
Are there any other member of the public that would like to speak to Senate Bill 38? Okay. Seeing none, we'll close the public hearing. Is there a motion to go into executive session? Okay. No, I don't think so. Okay. All right. Okay, the committee will be in recess to 1:45. I thought someone fell. Yes. We open the public hearing on Senate 26 and recognize the prime sponsor.
Thank you, Madam Chair. I'm going to try not to read anything. I'm just going to try to talk to you. We'll see if that goes, how it goes. Sometimes it goes good, sometimes it doesn't. Why did I bring this bill? A couple people have asked me. I think they're behind me. We did have an asbestos bill, Senator Whitley, about 5 years ago. Similar, but a little bit different. So what we want to do here is, well, I'll start off. I want New Hampshire to be the best place to live, work, and raise a family. I want businesses to feel comfortable here. I don't want people to forum shop New Hampshire, where 16 states have passed similar legislation to this, so they won't be forum shopped. We want to make it in tort law, tortum, simple word, Senator Whitley. It just, if someone wrongs you, I want there to be a nexus, a connection. Right now, when I went to law school a long time ago, and they had chalk blackboards still, and they taught us to sue everybody. They said anyone you can conceivably think of. So in these cases of asbestos, oftentimes, again, as I was taught and every other lawyer was taught 40 years ago, sue everyone who might potentially, even though you don't really have the causal relationship, and see where the chips fall. So I don't want someone just racking a ball of cue balls, if you want to use a pool analogy, and taking a shot because they're happy if any of them go in the pockets. I want you to have a specific cause of action when you name every party as a defendant. So this bill will force you to do that. If you do not do this, the judge will be able to excuse a party if he's within 30 days sees no causal connection. You would be dismissed without prejudice so that they could bring back the defendant at a later time if they find that there is a cause of action in discovery. So that's the causal relationship I want. There's a transparency aspect to this bill. Some might call it double dipping. I don't really look at it that way, but I look at it, if you were wronged, I certainly want you to be made whole or as whole as possible by the party that hurt you and injured you. And so to do that, if you prove the tort was done and that someone was injured, they should pay. But at the same time, I want, when they're awarding a jury verdict, I would like them to know that there's an asbestos trust fund there with between 25 and $30 billion. So that when the trial lawyers are trying this case, they don't want it to be known that there's this pot of gold on the other side. And so they want you to just think of, you're suing this person, then later on we can go again and hit this asbestos trust fund. So those are the two main things: transparency, so that a jury would be aware of all the money that might be entitled in a verdict. And I don't want overnaming. I don't want you to sue first. I want you to prove that the 60 people you named were all causally related to a wrong that was done to a victim. And so this bill was certainly not intended at all. We don't want to protect bad actors. I want everyone to get what's coming to them. Again, 16 states have passed such legislation, and I think it would do New Hampshire, it would send out a signal to the rest of the country that New Hampshire is not a place to forum shop. And I want to protect our small businesses, many who have supported it, including the Timber Association. They've had people wrongly sued and brought into litigation, and that's about it. I'll stop there. There are people on both sides of the argument who do this for a living behind me, who probably can answer more specific details than I could.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Senator Whitley?
Thank you, Madam Chair. Thanks for taking my question. So I'm curious whether this is really a problem in New Hampshire. Do we see forum shopping? Is there overnaming in New Hampshire? Is this a solution that's looking to solve a problem in New Hampshire?
So they have had such litigation in Massachusetts has had cases on this. New York has had cases. So we very well could come into such cases if we. It's to send the message out that New Hampshire is not a place to come do this. And if you do come here, we're going to have a transparent system so the jury is aware that there is an alternative revenue source, not just the one they're suing. And again, I want to be clear that I don't like the fact, I talked to one of our former attorney generals Saturday, they agreed with me. They didn't like the fact that people, that we're taught from the beginning to sue first and then find out the facts later. It's not the way I want to do business in New Hampshire.
Follow-up?
Follow-up?
I just have to say, I wasn't taught that in law school about just sue everyone. You know,
Okay.
you're taught there's ethical guidelines.
Sure.
So my question is, doesn't the existing, New Hampshire civil procedure rules, the rules of Superior Court, doesn't this already cover this issue? If you're describing a situation, if that happens, can't this just be solved by motion to dismiss? Why do we need sort of something beyond our civil procedure rules for one class of defendants?
I have a more learned colleague we was discussing that, and I think he'll answer the question better than I. So I'll let him follow that up.
Okay, are there any further questions? Seeing none, thank you very much, Senator.
Thank you, Madam Chair.
The chair will call Richard Head.
I have extra handouts if anyone else wants them. Good afternoon, Madam Chairman. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We do not have any position on the merits of this bill. We do, however, if this bill were to go forward, have three lines that we would ask to be amended. And that's what I handed out. And I'm just going to talk through very quickly what those amendments are. The first amendment is on page 1 of the bill, line 26. And essentially what this bill as written would require is the filing of various documents with the court. The court doesn't do anything with those documents when they're filed. The bill then provides that ultimately the defendant would flag an issue with those documents and ask the court to do something. But the filing of these documents with the court does nothing, and the court's not supposed to do anything with them. However, if these documents are being filed with the court, we have to establish a procedure for accepting them. We have to, if it's electronically filed, we may have to modify our e-filing system to be able to accept them. And we then have to sort of do something about having a document filed with us. The three parts that I'm asking to be amended deal with simply taking away the requirement that these documents be filed with the court, and instead that they be exchanged with the defendant. Very similar to the way discovery is done now. Discovery is managed between the parties. The court does not receive copies of discovery unless and until there's an issue. Somebody files a motion, files the supporting documents that relate to that, and the court then deals with it in the form of a motion as opposed to simply having documents filed. So the first change is on page 1, line 26. Instead of saying file all available asbestos trust claims, it would say provide to the defendant all available asbestos trust claims. On that same line where it says produce all trust claim material and file a sworn statement, instead that sworn statement would be provided to the defendants instead of filing it with the court. And then the third change is on page 2, similar change, line 3, instead of filing a sworn information form, it would be to provide that to the defendants. So that avoids us having to create a form, figure out how to get it filed, and then how to manage it. If there are any issues with any of the documents, the bill would provide that the defendant then can alert the court through a motion, and any of these documents could be supplied to the court at that time. With that, I'll close my testimony and be happy to answer any questions.
Thank you very much for your testimony, Mr. Head. Are there questions from the committee? Senator Whitley has questions.
Thank you, Madam Chair. Thanks for taking my question. So it's sort of a similar question to what I asked of Senator Gannon. We New Hampshire lawyers have rules of professional conduct. We have Superior Court rules that guide our civil procedure. From the judicial branch's perspective, is there a problem with our current rules of discovery, and does this bill solve that problem?
So thank you for the question. I don't know. I've not been involved in this bill. The only thing I did sort of try to figure out is I reached out to our court administrators to see if we track the number of asbestos cases that are filed. We don't, so I don't have any sort of data on the number of asbestos cases. So without sort of understanding the underlying reason, what triggered this bill, I honestly can't comment on it one way or the other as to whether or not there's a problem. We certainly do have rules of discovery. We have rules of ethics that govern lawyers and how a court case proceeds. So I don't know if this is trying to fix an issue that I'm simply unaware of, but I'm not aware of an issue.
Thank you.
Okay, are there any other questions from the committee? Okay, seeing none, thank you very much, Mr. Head.
Thank you.
The chair will call Kevin Grady.
Thank you, Chairman Carson. Ladies and gentlemen of the committee, for the record, my name is Kevin Grady. I am a 25-year Air Force veteran, and I am a 24-year resident of the town of Hooksett, New Hampshire. Today, I'm here representing the State Veterans Advisory Committee, and for those of you that might not be familiar with what we do, we're chartered by state RSA to speak for the veteran community in New Hampshire. We've been doing this since 2002, and every year, I, as the legislative chair, look at the bills that we have coming before us, and then we take a position on those bills, and then I come and I tell you what it is that our position is. I want to caveat my remarks today by saying we have not taken a formal position on this because we didn't get the language on this until after we had met last Tuesday. But I have carte blanche from our committee to go and tell you when we see something that looks like something we've seen before, like Senate Bill 335 from 2000, then and we took a very position in opposition to that bill, and I'm going to come here and explain to you why we oppose that, and we also oppose this bill here today. Why we have a dog in this fight is that nationwide, maybe 7 or 8% of people actually have served as veterans. But veterans make up almost a third of the mesothelioma cases in America. And that's what we're talking about here, are mesothelioma victims. It's used a lot on ships. So our Portsmouth Naval Shipyard is certainly in play here. It particularly affects our Navy vets, submarines as well. Having said all of that, I'm so happy to see a couple of attorneys on this panel. I am not an attorney. I don't play one on TV. So I'm going to give you this sort of from our perspective on this. This bill, and I was curious to read the analysis of it, because the analysis says people that don't have a dog in this fight, they're going to have their claim dismissed. And you know, I don't read that anywhere in the actual text of the bill, that, you know, except for these two things at the end of page 2, where it talks about the court on motion of a defendant shall dismiss a claim for this, shall dismiss a claim for that. I don't know how excited our judges are going to say what they think is pertinent in a courtroom, but here we are. As I see this, there is no requirement whatsoever, unless somebody can tell me something different. There is no requirement whatsoever for a person that gets mesothelioma to go to these trusts. There are over 60 of them that have been set up over the years. There's no requirement for them to go to these trusts before they decide they want to sue someone. And truthfully, when you get mesothelioma, let's be honest, shall we? You have about 9 months, maybe to a year to live. And if you want to have your day in court, then us veterans, we're not going to try and stand in your way. Now, there's a lot of things that, like I said, there's no requirement that I'm aware of that requires somebody to go to the trust fund first. So all of these things that deal with signing affidavits and telling what you've done with the trust fund, that stuff is all kind of non-applicable. It seems to us that a bill like this and the previous bill were designed for one thing and one thing only: to put as many obstacles between somebody who wants to have their day in court and them actually getting to go to a court and state their case. Now, let's keep in mind here that the people that are bringing a lawsuit still have to have, you know, by a preponderance of the evidence, and I hope I get this right, they've got to show that the people that they're suing are responsible for their mesothelioma, okay? So the burden of proof is still on them, regardless of what else we might read in this thing here. And as for the idea that we have to do this and we have to go to these claims first. You know, the truth of the matter is, if you're walking down the street and you get mugged by 3 people, you have a claim against 3 people, you know, not just one person. Okay, so there's plenty of opportunities in here for someone to do this. And to further illustrate my point about running the clock out and putting all these obstacles in the way, we have what I like to call the Devin McCourty last play defense here at the top of page 3. And it is basically around 60 days prior to the trial, you know, we can actually say, hey, have you gone to this trust over here? And according to this language, that person would be required to stop what they're doing and go and hit that trust up and see what they could do that. And the truth of the matter is, you do that about twice, and this person is going to pass away before they get to have their day in court. It is just that simple. When I started trying to get smarter on this, because my fighter pilot brain can only absorb so much, I started to ask myself, why would people put bills like this forward and go to places and try and sort of stack the deck a little bit? And it occurred to me that the insurance companies that have this liability, how do they make their money? They make their money essentially by managing risk. And it's the same reason that your 16-year-old male child, when they get their driver's license, if they want to have a muscle car like a Mustang for their first car, you're going to pay an arm and a leg and a small child for car insurance because they're protecting their bet here. And if I can put legislation like this in places that might be a little more friendly to me than other places, then I'm starting to stack the deck a little bit. And if I can run the clock out before these people ever get to a court of law, then I've managed that risk pretty well. So that's essentially why we don't support this. If a veteran or just anyone wants to have their day in court, we don't want to put things in their way. And again, I need to caveat my remarks with, we haven't taken an official position, but the position that I just laid out to you, I'm going to bet you with 99% probability is going to be the one that I'm going to take to the House should the bill advance to the House. And subject to your questions, and I may not be able to answer them, but I'm sure the expertise is behind me. I'll be glad to take any of your questions.
Thank you very much for your testimony. Are there any questions? Senator Gannon.
Just a non-legal question. Don't you think it's fair? So if they're suing my company and if I wrong someone, I should have to pay for it. But don't you think it's fair that a jury would know that they'll say, okay, the only money you're going to get is this money from Bill Gannon. But if there's a trust fund out there also, is that a terrible thing to do? That's half of what this bill is looking to do, to let them know that this alternative source, there's other money out there.
Presumably, the defense counsel can certainly bring that up at trial, and presumably all of these other avenues for filing other claims would be available in the discovery process. I'm just saying that I don't think we should mandate that they have to go do that. I don't think we should mandate that they have to go to the trust first.
Thank you.
Yes, sir.
Okay, are there any further questions? Seeing none, thank you very much, Mr. Grady.
Thank you.
Okay, next we're going to call Anthony Carr.
I'd like to thank the committee for the time to testify here today on this bill. My name is Anthony Carr, and I am a partner with Shaheen and Gordon. I am here because I have firsthand knowledge and experience with the actual state of asbestos litigation in the state of New Hampshire. So since that prior bill was introduced in 2018, approximately 30,000 civil lawsuits have been filed in New Hampshire State Court and New Hampshire Federal Court. That's about 5,000 a year for New Hampshire State Court and about 1,200 a year for New Hampshire Federal Court. And my understanding is out of those approximate 30,000 cases that have been filed, one of those has been related to asbestos personal injury. And that's a lawsuit that I filed in New Hampshire Federal Court back in 2019. That lawsuit was on behalf of a gentleman by the name of Barry Currier, who had been diagnosed with mesothelioma. And in that case, he was a truck mechanic for several decades in the state of New Hampshire. We named 4 defendants, and those 4 defendants were Ford Motor Company, Mercedes-Benz, Daimler Chrysler, and Rockwell, 4 very significant corporations with significant resources. I'm not aware of any real-life example of this generalized hypothetical concern actually coming to fruition in New Hampshire. And there are absolutely systems in place in the courts to deal with that should it arise for the first time in the future. There are motions to dismiss, motions for summary judgment. I can get Rule 11 sanctions if I just willy-nilly start naming defendants without a basis to do so. The last point would be to address Senator Gannon's question that was just raised in terms of the transparency and the fairness of all that. There are also systems in place in the course of discovery where materials like that can be requested by defendants. And in my particular case, they certainly did a discovery request for that. We may or may not object in a certain case. That's things that are very case dependent and that the judge will decide. In that particular case, we voluntarily disclosed. In that case, the plaintiff did file bankruptcy claim forms before and or during the pendency of that matter, and we voluntarily produced all of the claim forms. And there's, without going too much into the weeds, a set of laws in New Hampshire called De Benedetto, which then allows the trial defendants to point the finger at those entities plus even more. And so at the end of the day, what we had in that one case in 2019 is we named 4 significant big defendants, and those 4 defendants pointed the finger at 56 non-parties. And all the 4 I named, plus the 56 De Benedetto defendants, all 60 of those would have went on the verdict form at the end of the day had it proceeded to a jury trial. So for all these reasons, I would agree that this is a solution in search of a problem and would strongly oppose it. I'm glad to answer any questions.
Thank you very much for your testimony. Are there any questions? Senator Abbas and then Senator Whitley.
Thank you. I assume you're familiar with civil procedure in New Hampshire. If for any of the 4 defendants that were named, is there a procedure in place that they could have brought in a third party they believe was liable to the plaintiff?
Yeah, that's exactly what they did. They did that for not just the handful of folks that we had filed bankruptcy claim forms with, but also anyone that he had mentioned during his deposition as potentially being a source of exposure. So the burden of proof at that point actually shifts to us. There is a presumption that all 60 of those entities can go on the verdict form. We as the plaintiffs then have to file motions back at them on a one-by-one basis to argue why a particular one of those should not go on the verdict form. This is why, in terms of the form shopping, I had to laugh a little bit because New Hampshire is not known as a plaintiff-friendly jurisdiction at all. Folks are not going out of their way to file these cases in New Hampshire. I would say quite the opposite.
Thank you.
Senator Whitley.
Thank you, Madam Chair. Thanks for taking my question, and you did answer some of my prior questions too. So, you know, you had mentioned that of all the civil lawsuits that have been filed, really there has been only one. And the other thing that I'm sort of wondering about the, you know, the nature of this, whether there is a problem, I guess, is this sort of a unique the treatment that's being proposed for defendants in this bill, is this a unique treatment, or do we treat any other sort of class of defendants or class of plaintiffs this way?
No, this would certainly be unique treatment. There is already a rule in place in New Hampshire State Court, automatic disclosures, Rule 22, where you have both parties have an affirmative duty to produce certain materials right off the bat, absent any discovery request from the opposing party. So my burden is to produce materials that support my claims, and the defendant's burden is to produce materials that support their defenses. Mm-hmm. Part of my concern with the substance of this is that it tilts the odds in favor of the defendants. Now we, the plaintiffs, have a burden affirmatively to produce materials that not just support our claims, but support defendants' defenses in the allocation of fault. There is no converse or corresponding duty for the defendants. If we're talking transparency here, then why are the defendants also not having an affirmative duty to disclose materials affirmatively as well? They have things like catalogs, pictures that are incredibly helpful in these cases in the course of discovery.
Thank you.
Are there any further questions? Seeing none, thank you very much for your testimony this afternoon.
Thank you.
Okay, the chair will call Erin Voyik. Good afternoon, Ms. Voyik.
Good afternoon, Madam Chair, members of the committee. Thank you for having me. My name is Erin Boyack. As I said, I'm a vice president and the director of Asbestos Strategy and Claims Council at Riverstone Claims Management, which is a company headquartered in Manchester, New Hampshire. We employ nearly 200 folks in Manchester and approximately 200 in offices elsewhere. I've been with the company for 10 years. A little over 10 years now. Time flies when you're having fun. During that time, I have had extensive experience managing asbestos litigation on a nationwide, from a nationwide perspective. And I'm here in support of this bill for a couple of reasons that will be further detailed later on in other folks' testimony, so I won't belabor those points too much, but I will say it does a couple of sort of basic common sense things that we have consistently seen are problems in asbestos litigation nationwide. It requires that the plaintiff lay out basic information about what the allegations are against each defendant. That is something that's different from the bill that's been mentioned a couple of times. That was discussed 5 years ago and went to a study. That piece of the legislation addresses an issue that I see every single day, which is many of these sort of big plaintiffs' law firms, not New Hampshire-based law firms, nationwide-based law firms, file lawsuits that are based on form complaints. Those form complaints name hundreds, sometimes up to several hundred defendants in each of these suits. Many of those defendants are consistently dismissed from that litigation without payment. That dismissal is very expensive for our policyholders and for us to have that case defended through that dismissal. And that money only goes to defense lawyers. That is not money that is going to compensate claimants. That's not money that's going to our policyholders. That's money that's benefiting only one group, defense lawyers who defend these suits. The other piece of this legislation that we also support is around trust transparency. And this addresses a problem that we have seen nationwide where claimants file trust claims late in the suit. So the approach that they take during the tort portion of the suit is that only the solvent defendants who are still in the tort system are responsible for the injury. And then they file claims against the trust system. So as you'll hear, many companies have gone bankrupt as a result of asbestos litigation. And in fact, in recent years, we have seen a few of those companies cite overnaming as one of the reasons that they are in bankruptcy. We have seen hundreds of companies go bankrupt. Many of those companies are old tort defendants that you would be very familiar with. Johns Manville, Owens Corning, insulation manufacturers who claimants have been exposed to, and those exposures don't come out in the tort case. They come out later. And so what we are asking for as a defense group is a basic level of fairness so that we can understand what the quantum of liability is for a particular defendant and so that we can resolve those cases sooner. My perspective on this is that we would like to pay legitimate claims as soon as possible. We don't gain anything from defending a case for 2 years that could have been resolved the day it was filed for the same amount of money. We would like to pay that claimant immediately. The best way to do that is to understand what the quantum of liability is for our policyholder. So to understand what the total picture of liability is, and that's where the trust transparency component is relevant, and also to understand what the allegations of exposure are against that defendant. And if that defendant should not be in that suit, that defendant should be dismissed. That's basic elemental fairness and the way that the way that the litigation should operate. So I'm happy to take any questions from the committee.
Okay, thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
The chair will call Marissa Chase.
Good afternoon, Madam Chair, members of the committee. Thank you for giving me the opportunity to testify today. For the record, my name is Marissa Chase. I'm the Executive Director for the New Hampshire Association for Justice, which is a euphemism for the trial lawyers, as we all know. We are here today in strong opposition to this bill, as we were in 2018 when a very similar bill was introduced. This is not a problem in New Hampshire, as you've heard from previous speakers. I'm going to try to not reiterate any testimony you've already heard. But I do want to emphasize that this is helping one specific class of defendants in our civil law where these cases aren't even happening in New Hampshire. We did a Lexis search. I should say Attorney Scalambrini, who meant to be here today but got stuck in a client meeting, did a LexisNexis search and found in the entire available history of New Hampshire case law, only one asbestos case. That's a couple hundred years. New Hampshire also, I would note, does not have punitive damages, so it is more beneficial to file these claims elsewhere. That's not something that's going to change. Frankly, I see this bill as trying to use New Hampshire as an opportunity to pass this legislation in a few states and then tackle states where it actually does happen. I would also say that the trusts are organized by the federal government, so nothing that we can do in by New Hampshire state law would change that. They have their own specific code in the bankruptcy, federal bankruptcy law, 524G. The trusts were organized by the federal government in 1994 when large companies, corporations with asbestos liability went to Congress and asked this to be created so that they could file bankruptcy. And filing bankruptcy, I think there are a lot of different ways to do it. That's something else we should be clear about. Companies can file bankruptcy in a way that sheds their liabilities while reorganizing and continuing to do business as a solvent entity. So there's not just one form of bankruptcy. I just want to point out there are over 8,000 unique asbestos defendants that we know about. On average, less than 1% are named in a civil suit. I would also say, if I were running a company that I knew had asbestos liabilities, I probably wouldn't be super forthcoming about all the people I probably harmed. That's why the discovery process is important, and putting hurdles and burdens for one party in a case that another party doesn't also have to prove is completely unfair. Let me see. I apologize. This bill has been introduced in 6 states in 2021 and 2022 where it was introduced, but those states did not enact this: New York, Missouri, Illinois, Ohio, Texas, and Georgia. I would say that Fortune 100 companies that make a profitable business decision to purchase liabilities and are going into states to ensure profit, that their decision is profitable, that's a private business decision. New Hampshire has no business interfering in that. With all due respect, I didn't mean that harshly. It's my understanding that there is about $30 billion left in the trust. About $20 billion have been paid out of that. 83% of all asbestos actions come from just 15 jurisdictions across the country. None of them are New Hampshire, and overall claims of asbestos are down 15% today from 5 years ago when this bill was initially introduced. The average trust payment is pennies on the dollar. It's $41,000, which does not cover the average $1.5 million in medical expenses that an individual with mesothelioma is expected to pay. And I'm happy to try to answer any questions.
Thank you very much for your testimony, Ms. Chase. Are there any questions from the committee? Senator Gannon?
Just a quick question, because I keep hearing from different parties, this doesn't exist in New Hampshire. But I know asbestos does, because I do stage curtains, say there's asbestos curtains hanging many schools still in New Hampshire. There's pipes probably in this building that still have asbestos, so it could come. Just because it hasn't, there is asbestos all over the place. So this litigation could come here.
Senator Gannon, I would respectfully say that since asbestos litigation really started in the 1990s, if it hasn't come here, it's not going to. There are different jurisdictions. We heard 83% of all asbestos actions come from just 15 jurisdictions across the country. There are 15 jurisdictions that have active asbestos dockets, that judges know how to deal with these, that parties are well versed in the laws in those states. New Hampshire's never been one of them, and again, we don't have punitive damages. We don't have runaway juries. That's just not us.
Okay, thank you.
I have a question, Ms. Chase. Mr. Head from the judicial branch came in and testified, basically starting on line 24 with the required disclosures by the claimant, that instead of filing all available asbestos trust claims, that they provide to the defendants. Is that something that is appropriate?
Frankly, I think that's kind of the discovery process now. I don't think that changes much, and that wouldn't change our position on the bill.
Okay. Okay, thank you. Are there any other questions? Okay, seeing none, thank you very much.
Thank you.
The chair will call Mark Behrens. Good afternoon.
Chair, committee, be here today. My name is Mark Behrens. I'm testifying today on behalf of the U.S. Chamber Institute for Legal Reform. I'm a national expert in asbestos litigation. I've probably written more about this litigation than anybody over the last 22 years or so, and I've testified in a lot of committees similar to yours on bills like this over the years. So I wanted to share my perspective today and brief you a little bit on why asbestos litigation is unique and why we're talking about it today. Most people would, might be surprised to find out how long this litigation has been going on and how long it's going to go. The first asbestos lawsuits began in the early 1970s, so we're 50 years into this litigation now. And the estimates are that it will continue through at least 2050. This is the longest running national mass tort we've ever had, in part because of the ubiquitous nature of asbestos products. Asbestos was a mineral that was seen as a wonder mineral because it was fireproof and so forth, and it was strong. It could be used in a lot of different applications. And in the 1970s, 80s, and 90s, there were literally hundreds of thousands of lawsuits that were brought by people alleging asbestos-related disease against the so-called asbestos industry, the companies that made the asbestos insulation, and other companies that were part of the industry. The litigation has changed very substantially because of that avalanche of lawsuits that came over a multi-decade period. By the early 2000s, that so-called asbestos industry, the traditional defendants in this litigation that made insulation and were alleged to have not warned about it, those companies were all forced into bankruptcy in a wave that happened in the early 2000s. There are now roughly 140 companies that have gone bankrupt because of asbestos lawsuits. And the bankruptcy code as it deals with asbestos is unique. When a company files bankruptcy due to asbestos-related liabilities, it will emerge from bankruptcy with immunity. So the companies that for decades were blamed by the plaintiff's bar for causing their clients' diseases, those companies cannot be sued today in the tort system. And I think that's important for you to understand, because you'll hear about, maybe, we didn't hear this today, but in other states I hear about, oh, this is a bailout for the asbestos industry. Okay, the asbestos industry doesn't exist. It went through bankruptcy and it's immune. You look at complaints today, those companies are not listed because they cannot be sued in the tort system. But as part of the bankruptcy process, each of those companies that goes through bankruptcy creates a trust that is left behind with proceeds from the company's assets and insurance to pay people that are exposed to their products that get sick. So if you are a claimant that worked around a ship or a naval facility or something like this, a veteran, and you were exposed to these products of companies that have gone bankrupt, you don't have a tort claim against them, but you can file a claim with the trust that were set up by these companies. And the trust system is set up to pay people quickly and easily. It is seen as an alternative, it is an alternative to the tort system. And that's where people go that were injured by products from these bankrupt companies. I brought with me a sample of a trust claim that I can give to the committee so you can see what it is. But this is the whole thing. I printed, this is one from the Narco Trust. They all look the same. And it's a bunch of boxes to check. If you were familiar with a client's case and you couldn't fill this out in an hour, I would be shocked. And these plaintiffs' lawyers are taking a full contingency fee in many cases by filling out these boxes. But this is what a trust claim is. So a lot of people thought that when the bankrupt companies were no longer subject to lawsuits, and plaintiffs have this easy method of recovery against the trust, that the litigation would sort of move out of the tort courts and into these administrative system. But it didn't happen that way. A couple of things happened that the legal system is still struggling with today, 20 years later.
And these are the two issues that go to the heart of this bill. One of the things that we saw happen is that the litigation morphed. And it went from being lawsuits against these deep pocket asbestos industry to small and mid-sized businesses all over America. The first asbestos lawsuit had less than a dozen defendants. Today, we routinely see cases where the number of defendants is anywhere from 60 up to over 300. The number of companies that have been sued in asbestos in the United States is now over 11,000 different companies. So this litigation has moved from culpable deep pocket defendants to little or no culpable small businesses and medium-sized defendants. That was something that people didn't foresee at the time. Those are the defendants that we see in the cases today. And when you have 11,000 defendants, it makes sense. There aren't 11,000 Fortune 500 companies. We are really out on the periphery of companies that have culpability in this litigation. But that's one of the things that we saw is this expansion of the litigation to very peripheral companies. And as part of that, what we're seeing is, frankly, indiscriminate naming of companies in many of these lawsuits. There are lawyers across the country that file claims, with hundreds of defendants or dozens at a minimum in their lawsuits without doing any due diligence whatsoever to whether those companies belong in the case. And as you might expect, when there's indiscriminate naming of defendants in lawsuits, and it eventually comes out that many of those defendants have no connection to the plaintiff whatsoever, they're dismissed. And so for too long, people would think, well, no harm, no foul. And this, Senator, goes to your question about, don't we have mechanisms to deal with this today? Yeah, eventually you'll find out that you have, if you're a defendant that's an innocent company that has no connection to this plaintiff whatsoever, eventually that will come out and you'll get dismissed from the lawsuit. But we don't have a loser pays system in America. So that small business has had to hire a lawyer, answer a complaint, respond to discovery, attend a deposition. They may run up $20,000 or more in legal fees in a case where they never belonged in the first place. And the rules today don't provide for a mechanism to deal with that. But the bill does, in a very fair way. What the bill says is simply, tell us the facts that support your lawsuit. If you're going to sue me, let's say I represent an auto dealer or a plumbing supply store or a hardware store here in New Hampshire, and you're going to sue me, you should have to tell me why. You should have to be able to tell me, I'm suing you because you sold this product at this period of time and I'm sick. And if you can't tell me why I'm being sued, then you shouldn't sue me. And just by that simple, basic, factual disclosure, tell me why you're suing me. What the bill tries to do through this disclosure is filter out the companies that belong in the lawsuit, that do have a connection to the plaintiff and may owe the plaintiff money, from the innocent companies that have nothing to do with the plaintiff's injury. And so this isn't about protecting any culpable people. It's about letting those that are innocent obtain earlier dismissal than they do today. And we have veterans in our family. There's no veteran that would stand up and say, you ought to have a right to sue innocent companies that have nothing to do with the plaintiffs. And that's what this bill tries to deal with. That's the problem that it's addressing. And it will do it in a way that is good for plaintiffs. As you heard Aaron say, if the companies that are responsible, so again, it's a filtering mechanism. And the goal here is, let's take out the companies that don't belong in this lawsuit. Let's focus the lawsuit on the companies that do belong, that the plaintiff was exposed to their products, or likely was. If those companies have more information earlier on about the exposures, they're in a position to settle that case earlier. If this bill passes, it will streamline litigation and sick people will get paid faster. That's a pro-plaintiff mechanism. And I hope that is not lost on the veteran community. The other thing that we've seen that this bill addresses in this newer environment that we've seen over the last few years is that plaintiffs today do have these two avenues of recovery. They've got the trust claim that they can file, And there's a lot of money available in the trust, some $30 billion. And there was a study a few years ago, it came out in a case called Garlock, that said an average, it is not a burden to go get $500,000. And if you ask anybody on the street today, would you rather have $500,000 today or 3 years from now? Every one of them would say, I'll take it today. So asking people to go get paid faster is not a burden. It's something that they should be doing. And the only reason that's not happening is that there are lawyers in other states that are manipulating the trust claim system. They're manipulating the filing of these trust claims so they're not available in the tort suit. Why? Because they're trying to hide those exposures. And the power of this goes to the situation that the prior testimony discussed, where there was a case against, I think it was 4 defendants today and 56 trusts, meaning the plaintiff signed a claim form alleging exposure to 56 other products that caused his injury. Isn't that relevant? Would it be fair for those 4 defendants to sit there and have a jury to be misled to believe that the only exposures the plaintiff ever had were to those 4 companies? When the plaintiff has filed a form and himself said 56 others are responsible? No, the jury should have all that information. And that's what this bill does. It doesn't protect anybody that's engaged in wrongdoing. It's simply saying, let's get all the cards out on the table. Let's hear the jury about the exposures to the 4 companies that are in the lawsuit, and let them hear about the 56 other companies that aren't in the case, but did have something to do with the plaintiff's harm. And give all that information, and then let them allocate fault wherever it belongs. And the bill will do nothing to immunize anybody that gets a percentage share on the lawsuit. So that's essentially the how and why of this bill. We've heard a lot today that this is a solution in search of a problem. It isn't. I think there are a number of reasons why this bill is important to pass here in New Hampshire. One is, you do have an asbestos lawsuit. We've talked to other lawyers that say over time there have been some lawsuits here, and there have been defendants that are dismissed. The other is that the nature of this litigation moves. We've seen it move from which defendants are getting sued to, and we also see it move from one state to another. These lawsuits are brought primarily by what I call the TV lawyers. They're in Texas, they're New York City, they're Philadelphia. You see the ads on TV. Your local New Hampshire plaintiffs' lawyers can't compete against that. These are firms that are spending tens, if not hundreds of millions of dollars a year on advertising to recruit these cases. Those are the lawyers that are engaged in these practices we're talking about. Those are the lawyers that are filing huge complaints without doing their due diligence. Those are the lawyers that are hiding the ball with the trust claims to prevent the juries from being fully informed. And those are the lawyers that should have to play by fair rules. So we've seen them file cases in different places, and they could come here because in the last decade or so, 16 states have passed transparency reforms. More are doing it all the time. And to the extent that these laws get passed in other states, they will look to forum shop. And the New Hampshire businesses that we work with don't want them to look here as a place to do that. And then finally, this is an important message about the fairness of New Hampshire's legal climate. This is not a bailout bill for anybody that has ever done anything wrong. This is simply saying, sue the right companies and let juries get full information to determine who's responsible. There's nothing more fair about that. And, it would send an important message to the business community nationally that to pass this bill as a strong signal of this state's commitment to a fair and free legal system. And with that, I'd be happy to answer any questions that you may have.
Thank you very much for your testimony. Are there any questions from the committee? Senator Whitley.
Thank you, Madam Chair, and thank you for taking my question. So, I do think, I have to say, New Hampshire does have a very high caliber of practice in New Hampshire, so surely our bar could compete with lawyers from New York City. But what I'm interested in is, our New Hampshire businesses. We have heard from 2 other lawyers who do practice in New Hampshire that there's only been one asbestos case in hundreds of years. That's what we heard. And so what I'm curious is, has any New Hampshire business been negatively impacted in this way that you're describing, that requiring us to create this whole new set of requirements for only one set of defendants? Are New Hampshire businesses being put out of business because of this?
Senator, it's a fair question. You know, of the 140 or so companies that have gone bankrupt because of this litigation over the last decades, I don't know which ones have had operations. These are national companies. So, you know, I would be shocked if some of them didn't have operations in this state. So I suspect the answer is yes, absolutely. Jobs have been impacted by this litigation over the course of it. But again, this is just about providing fairness and disclosure. And, you know, it's not about protecting anybody that's done anything wrong. We shouldn't have to get to the point where innocent companies are routinely being named in lawsuits in this state before the legislature acts to help them out.
Follow up?
Yes, follow up?
Thank you. So you indicate that this is about disclosure, but, you know, even without this bill, that disclosure will happen because you have, you know, assuming you have two lawyers of high caliber practicing, that disclosure will happen. It's not like without this bill, that disclosure won't happen, and without this bill, juries won't know about it, correct?
Well, Senator, let me parse this a couple of ways. So on your first point, will the information eventually come out about the plaintiff's exposures? Some of it will. So, you know, many of these companies that are being innocently named do, through the process of discovery, eventually find out, look, I didn't belong in this lawsuit to begin with. But they're finding that out after they've spent, you know, maybe $20,000. You tell a small business, it's it's an auto parts supply store that's working on a very thin margin, and then you just say, we're going to throw a $20,000 expense at you that's complete nonsense. That matters to those family businesses. It matters a lot. And so, you know, that's money they don't get back, and time spent they don't get back. So, eventually the system corrects for that problem, but in a very inefficient and unfair way that would be solved by the bill. The other way that discovery doesn't work today is, in New Hampshire, there is no mechanism to compel plaintiffs today to file those asbestos trust claims. Now, you know, the reality is, if you're a plaintiff and you can obtain $500,000 today, almost no questions asked, why wouldn't you do that? Unless your purpose is to hide that information from the jury, so that the trial defendant can't put on a fair defense and can't give the jury full information so they can make a fair decision. And that does happen. What we've seen, you know, all across the country over and over again is that the information on these trust claims, they do delay filing them with the intent of preventing defendants from getting access to that information. And when plaintiffs are deposed, tell me about what products you worked around, they are prepared well by their lawyers to recall being exposed to all of the solvent companies' products in the lawsuit. And frequently, when they're asked, do you recall being exposed to any of these 56 bankrupt companies? More often than not, the depositions I see, the plaintiff says, I don't recall. Why? Because the lawyer hasn't refreshed their recollection as to those other exposures.
Follow up?
Yes.
So, you know, our New Hampshire small businesses are really the backbone of our economy, of our small towns. You know, of course, you know, I would say that, you know, we want to support our small businesses, yet I haven't heard that it's impacting our businesses. So that's my first sort of issue. And then the second issue is the issue of frivolous claims. That is not a situation that's unique to asbestos litigation. Frivolous claims are going to impact small businesses in all types. So I guess my question is, I don't understand why we are just protecting, you know, this group of defendants against frivolous claims, but not another.
I think the answer to your question is this litigation has seemed to have lived by its own set of rules for all of these years. You know, courts apply different standards on causation in these cases and others. So it is different. You don't have situations in any other case, to my knowledge, I've never seen it, where you have 60 to 300 defendants named in a lawsuit. Like you said, New Hampshire plaintiffs' lawyers, they're focused on slip and fall, med mal, the routine things that personal injury lawyers do. They do their due diligence in those cases. They don't sue every doctor in the hospital. They sue the ones that were involved in the patient. They get the patient's records. They sue the doctors that are involved. Asbestos is the only type of situation where it's, let's sue every doctor in the hospital, and then we'll figure out later which ones might have been responsible. You just don't see that happening in other contexts. Asbestos is unique. The trust claim process is unique to asbestos. So there's lots of different things going on in asbestos that make it unique. And we do see these frivolous claiming activity in asbestos and fraudulent claiming activity in asbestos that just doesn't happen in other contexts. And, the last point I'd raise about your question about, do small businesses care about this in this state? I think you've heard testimony from at least one major insurer, but I understand that the BIA supports the bill, the lumber retailers support the bill. There are other businesses that are going to come forward that support this bill. Obviously, they're doing it because they believe it's important for their members that are here in the state.
Are there any further questions?
Just
Okay,
a quick.
Senator
sorry.
Gannon?
I'll be really quick and then you can go. You mentioned the Retail Lumber Association. They didn't give specifics, but they did talk about in the letter to all of us, said that they've often been dragged into asbestos-related lawsuits. So I'm believing that there must be more than just this one lawsuit if the Lumber Association are saying their members have been dragged into asbestos lawsuits. Have you heard this?
Senator, I have heard that there have been other asbestos lawsuits brought here in the state.
Okay, thank you.
Okay, Senator Abbas?
Thank you, Dr. Chair. And thank you for taking my question. If a plaintiff were to pursue a frivolous claim, isn't there remedies against the law firm or plaintiff's attorney that brought the frivolous claim that the defendant could bring? And have you seen any of those in asbestos litigation brought within New Hampshire or other states?
Yeah, Senator, it's a good question. And, I would tell you, if you look over the 30,000 cases that were filed in New Hampshire over the last 5 years, I think it was said, and you were asked how many so-called Rule 11 sanctions were filed in any of those cases, I'd be surprised if it's more than 10. Lawyers don't file those. There is an ethical duty, to have a reasonable, good faith basis to file a lawsuit. For whatever reason, we don't see that happening in all asbestos cases. Again, it is against, I'm not saying that the case is frivolous. It is as to certain defendants that are named that have no connection to the plaintiff. There may be some legitimate defendants in that case. There may be others that are not. And it really goes to, if you're a small business and you've already paid out $20,000 in a case where you never belonged to begin with, the last thing that you're going to do is call your lawyer and say, go spend more money filing a sanctions motion to maybe get our court costs back of a few $100. I mean, what happens is these companies are, innocent companies are routinely named and then dismissed, and they make a business decision to cut their losses and move on. So the last thing they are going to do after they've spent a whole bunch of money on legal fees is spend more money on legal fees in a case they never belonged to begin with. And that's why we don't see these motions being brought. Courts don't want to fool with them. And so, what happens is we're in this system today where it's just spend money on defense cost. Nobody benefits from this system other than the defense lawyers. And, it's just not right. And this bill, I think, is a very fair way of solving that problem of filtering out the innocent companies from those that do belong in the lawsuit.
Thank you, Madam Chair. And thank you again for taking my question. In your experience of the defense attorneys that are retained, are they retained by insurance companies? Or are they private counsel by each of the businesses?
Senator, it's a mix. There are many of your larger companies would be what we call self-insured, meaning it comes out of the company's bottom line. When you deal with smaller companies, mid-sized companies, a lot of those, have insurance. So it's a mix between those that pay out of pocket and those that pay through insurance. But either way, somebody's paying, and having money spent on defense costs in a case where that defendant never belonged is draining assets. So if it's a defendant company, if it's a small business, if they have insurance, it's still eroding, it may still be eroding their insurance. So let's say 5 years from now, somebody comes forward that is sick, that company was responsible for. Oh, I'm sorry, we don't have money to pay the sick guy because we spent the money in a bunch of frivolous lawsuits on defense costs. That's something we want to try to stop.
That's it. Okay, are there any further questions from the committee? Seeing none, thank you very much.
Thank you very much for your time today. Appreciate it.
Are there any other members of the public that would like to speak to Senate Bill 26? Okay, seeing none, I'm going to close the public hearing. And thank you all for being here this afternoon. We've concluded our business.
It's something that